And at the moment, I recognize Senator Van Hollen for his opening statement.
Thank you, Mr. Chairman. Welcome, Attorney General Bondi. I have two questions. Number one, I assume you agree that zealous advocacy does not mean telling untruths to courts of law. And second, if that's not the case, what did you mean by saying he was not a zealous advocate?
Senator Van Hollen, this is all pending litigation, as you're well aware, and the timing of it, I can't discuss pending.
What if standing up for the truth meant losing everything? For Arez Ruveni, a dedicated 15-year veteran of the Department of Justice, this was the devastating reality he faced. Fired not for wrongdoing, but for refusing to sign a false legal document, Ruveni's chilling words, "I didn't sign up to lie," now echo through the halls of justice.
You said yourself you're very concerned about foreign influence on our government.
Senator, it is wildly offensive that you would accuse President Trump of not protecting American interests in our country when he is the president that has shut down our borders, unlike Joe Biden. Trump has done everything to make America safe, and you asked me the question, and keep America safe.
His whistleblower complaint has exposed a dangerous culture of retaliation where truth is punished and loyalty is demanded at any cost. Ruveni's complaint is a striking one. He alleges that, after years of serving the DOJ with integrity, he was terminated for upholding the very values that the department is supposed to represent: truth and honesty in the legal process. According to Ruveni, the situation reached a breaking point when he was instructed to sign off on an appeal brief related to a case he felt was fundamentally flawed. He refused, stating that he could not, in good conscience, lend his name to a legal document that lacked factual or legal support. His refusal to comply was met with consequences that many would find deeply troubling. In his words, "I didn't sign up to lie." For Ruveni, this wasn't just a matter of personal ethics. It was about standing up for the integrity of the legal system. The brief he was asked to sign was, according to him, built on falsehoods and could have led to a miscarriage of justice. Yet, his refusal, rather than being respected as an act of professional integrity, led to his dismissal. This is not just a case of a simple internal disagreement or a messy termination. It's a matter that speaks to the very heart of the DOJ's commitment to justice and ethical conduct. When a person like Ruveni, with such an established track record, is punished for refusing to lie, it raises serious concerns about the priorities of the department. The core of the whistleblower complaint is clear. Ruveni was reportedly fired because he refused to sign a legal document he believed was fundamentally flawed. It's important to understand the implications of this claim. A legal brief, especially in the context of an appeal, is not simply a formal document. It is an instrument that can have far-reaching consequences. If it is based on inaccurate information or unfounded legal arguments, it has the potential to harm not just the immediate parties involved in the case, but the broader public trust in the justice system itself. In a legal environment, the importance of upholding truth and accuracy cannot be overstated. What makes this case particularly striking is the backdrop against which it unfolded. Ruveni's tenure at the DOJ was marked by a series of commendations and accolades for his work. His reputation within the department was strong, and he was seen as a reliable and competent attorney. During the Trump administration, his contributions were recognized, and he appeared to be a valued member of the DOJ team. Yet, despite his strong record and the praise he had received, Ruveni's willingness to stand by the law and not a flawed legal brief was the very thing that led to his downfall. It's also important to note the context in which Ruveni made his decision. By all accounts, he did not act out of a desire to make waves or seek personal glory. Rather, his actions seem to have been motivated by a sense of professional duty and a commitment to ethical standards. His refusal to sign the appeal brief was not a spur-of-the-moment decision. It was a deliberate, principled stance. Ruveni has made it clear that he believes signing the brief would have been a betrayal of everything he had worked for during his career at the DOJ. The case has become a powerful symbol of the challenges that many government employees face when they are asked to make difficult ethical decisions. It's not uncommon for employees in various sectors, including law enforcement and the legal profession, to find themselves caught between the demands of their superiors and their own moral compass. Ruveni's story highlights the high stakes involved when the call of professional ethics clashes with the pressure to follow orders. In the world of law, the responsibility to uphold the truth and to act in the best interest of justice is paramount. But what happens when doing so comes at a personal cost? In Ruveni's case, the cost was his job. His career, which had spanned 15 years, was effectively ended when he refused to take part in what he viewed as an unethical action. And in the wake of his firing, Ruveni did what many might consider a courageous step. He filed a whistleblower complaint. In his complaint, he outlined his experience at the DOJ and the reasons behind his decision to refuse to sign the appeal brief. His action was a bold move, one that many would argue took significant personal and professional courage. But it also opened up a much larger conversation about the role of whistleblowers and the protection of truth within institutions that are supposed to uphold the law. Whistleblowing is a fraught and complex issue. While whistleblowers are often hailed as heroes for exposing corruption, malpractice, or unethical behavior, they frequently face retaliation. The legal protections for whistleblowers, while improving in some areas, are still not universally strong enough to shield individuals from the consequences of their actions. Ruveni's story serves as a reminder of the risks that whistleblowers face when they stand up for what is right. It is not just about losing a job, it's about the very real personal and professional costs that come with challenging the status quo. This brings us to a broader and perhaps more troubling issue. What does it say about an institution when its employees feel compelled to speak out against unethical behavior? The case of Arez Ruveni is not just about one man's career. It is a reflection of the challenges faced by employees within large institutions when they perceive wrongdoing or unethical practices. It raises fundamental questions about the values that are upheld within these institutions, and whether employees who hold the line on ethical conduct are supported or punished. In many ways, this story is not just about Ruveni, it is about the broader implications for how institutions, including the DOJ, handle situations where employees are asked to compromise their integrity. What happens when the line between legal advocacy and ethical conduct begins to blur? When zealous advocacy is used as an excuse for unethical behavior, what safeguards are in place to protect those who refuse to participate in that behavior? These are difficult questions that require careful consideration and, above all, a commitment to ensuring that the values of truth, integrity, and fairness remain at the forefront of the justice system. Arez Ruveni's experience is one that speaks to the heart of these concerns. His refusal to sign an unethical legal brief is a reflection of the internal struggles many employees face when their personal ethics are at odds with the demands of their jobs. It is also a powerful reminder of the importance of protecting whistleblowers and ensuring that institutions remain committed to upholding the truth regardless of the consequences. As this case unfolds, it will undoubtedly serve as a critical point of reflection for the Department of Justice and other institutions faced with similar ethical dilemmas. What kind of legal system do we want? One that punishes those who refuse to compromise on the truth? Or one that supports and protects those who stand up for what is right? The answer to that question will shape the future of our legal institutions and the role of ethics within them. The whistleblower case involving Arez Ruveni did not end with his complaint. In fact, it escalated when the matter was raised in a Senate hearing where Attorney General Pam Bondi was confronted about the allegations made by Ruveni. The ensuing exchange highlighted the stark divide between the DOJ's official stance and the concerns raised by Ruveni, as well as the broader implications for the justice system. Senator Chris Van Gollen led the charge during the hearing, questioning Bondi on the specifics of the case and pushing for transparency on the firing of Ruveni, who claimed he was dismissed for upholding his ethical duties rather than for any professional misconduct. This public confrontation, which quickly gained attention, revealed not only the specifics of the case, but also some deeply troubling aspects of the Department of Justice's handling of both Ruveni's dismissal and broader concerns within the department. When Hollen directly questioned Attorney General Bondi about Ruveni's firing, Bondi did not immediately offer a clear denial of the accusations. Instead, she pointed to her earlier statement on Fox News, where she stated that all DOJ attorneys were expected to zealously advocate on behalf of the United States, and that any attorney who failed to do so would face consequences. However, this definition of zealous advocacy seemed to leave many questions unanswered, particularly in light of Ruveni's specific allegations. In fact, Hollen pressed Bondi on whether zealous advocacy meant lying or making untruthful statements to the court. A key issue in this case, since Ruveni's refusal to sign the appeal brief stemmed from his belief that it was factually and legally unsound, Bondi's response was evasive, relying on the fact that the matter was part of pending litigation, which, in her view, prevented her from offering any specifics about the case. She also mentioned attorney-law privilege and suggested that the timing of Ruveni's allegations was suspicious, given that they coincided with the Senate confirmation hearing of Amal Boy, an individual with strong ties to Bondi. Bondi's remarks, however, only raised more questions. Rather than addressing the core issue, whether the DOJ was retaliating against an employee for standing up for the truth, she shifted the focus to the timing of Ruveni's complaint and his criticisms of Bowie. Bondi described Bowie as a brilliant and moral individual, someone who she stood by, implying that the allegations against Bowie were unfounded. Bondi's defense of Bowie and other members of her team quickly turned into a personal loyalty pledge, not an investigation of the underlying issue. It seemed as though the loyalty to certain individuals within the DOJ took precedence over the important task of addressing Ruveni's whistleblower complaint, which concerned the integrity of the department and its practices. Hollen was not satisfied with Bondi's response, particularly as it appeared that the central issue, the dismissal of an attorney for refusing to lie, was being downplayed. He pointed out that Ruveni's case was not an isolated incident. According to Hollen, other employees within the DOJ had quietly expressed their discomfort with being asked to carry out what they viewed as unethical tasks. These concerns, he argued, were symptomatic of a broader issue within the department, a culture where loyalty to superiors or political agendas was rewarded, while ethical behavior and truth-telling were penalized. Hollen's comments reflected a growing concern that the DOJ was becoming a place where truth was secondary to political considerations, and where employees who refused to go along with unethical actions were punished. What made the hearing particularly difficult to ignore was the fact that Bondi, while offering strong defenses of her colleagues, failed to provide any meaningful insight into the underlying allegations. Instead of discussing how the DOJ planned to address the systemic problems that might have led to Ruveni's dismissal, she deflected to issues of timing and personal loyalties. In essence, Bondi appeared to be prioritizing the protection of her team and the department's image over engaging with the serious allegations of misconduct within her office. The situation took a darker turn when Hollen raised another critical issue: the recent decisions made by the DOJ regarding grant funding. The department had terminated numerous grant awards without notice, leaving many grantees in limbo. These were not small cuts. Hundreds of grants, including those funding law enforcement training and victim services, were suddenly wiped out, effective immediately. This had a direct impact on communities that rely on these funds for crucial services, such as shelters for victims of crime and legal aid for underserved populations. As if that wasn't troubling enough, Van Gollen pointed out that the DOJ had also been withholding new notices for funding opportunities for the current fiscal year. The result was that many organizations, particularly those that assist victims of crime, were unable to apply for new funding or even plan for the future, as they had no idea whether they would be receiving the necessary financial support. Bondi's response to these concerns was somewhat predictable. She acknowledged that grants had been cut by 6%, but downplayed the severity of the situation, offering an appeal process for senators whose states had been affected. While she claimed that grants were being evaluated on a case-by-case basis and promised that new notices of funding would be issued soon, it seemed as though the department's funding strategy was rooted more in political considerations than in a well-thought-out plan to address critical needs. The idea that senators would need to personally contact Bondi to have specific grants reinstated came across as a form of political favoritism, rather than a transparent and fair process. The concerns raised by Van Gollen were echoed by many others. They suggested that the DOJ's funding decisions and the broader treatment of whistleblowers like Ruveni were symptomatic of a department that was more interested in protecting its political image than ensuring ethical governance. Van Gollen's attempt to get Bondi to address the core issue that the DOJ was reportedly silencing employees who refused to lie was met with vague promises and non-answers. Bondi failed to outline any concrete steps the DOJ would take to address the apparent culture of unethical practices, and her focus on defending her colleagues raised concerns about whether loyalty to individuals had begun to outweigh a commitment to ethical conduct. As the hearing continued, it became increasingly clear that the problems within the DOJ extended far beyond a single whistleblower's allegations. The culture of retaliation against truth-tellers and the deep concerns about the ethics of the department were troubling, and Bondi's responses seemed to signal a lack of accountability. Even when Van Gollen pushed her to address these issues more directly, she continued to deflect, refusing to engage in a meaningful way with the concerns about the department's practices. At the heart of the matter is whether the DOJ is truly committed to upholding the principles of justice, or whether political loyalty has become more important than ethical conduct. Arez Ruveni's case and the broader concerns raised during the Senate hearing point to a troubling reality. The justice system is only as strong as the people who uphold it. And when those individuals are silenced or retaliated against for doing what's right, the entire system suffers. The DOJ's response to these challenges, deflecting, downplaying, and delaying, has only intensified the questions about its commitment to truth and justice.